Today's topic is search and seizures, where we are going to explore the various powers, the provisions, the remedies, the recourse, and the safeguards which are there in the powers which mandate search and seizures. Now, search and seizures are codified under the CrPC, which gives us power to the courts as well as to the police officers, as well as under special acts where provisions are made for the various officers who are empowered under those special acts to conduct search and seizures. Now, the reason why all these powers are codified is because when invoking them, it affects and there's a temporary suspension of a person's fundamental rights, whether it's a right to privacy or right to a livelihood, right to conduct a business, or even when he has a legitimate right to enjoy any property. Today, considering that the topic is vast, we are going to deal with only one part of it, which is the search and seizures which are conducted under the authority of courts. Now, the provisions pertaining to the issuance of search warrants by the courts can be found in Chapter 7 of the CrPC. Sections are namely Section 93, 94, 95, 97, and 103. Now, these provisions exclusively give power only on authority of the courts. That this is cannot be exercised by any officer or any other person under any other act, and it is specifically given to the courts to compel the production of any document or article or person as it may require under this act. Now, Section 93. Now, Section 93 permits that a court can only issue a warrant under three circumstances, namely when the court has a reason to believe that a person who can be summoned to produce a document or thing will not produce it. Two, when the document or thing is not known to be in the possession of any person. And three, where a general inspection or search is necessary for the purpose of any inquiry, trial, or other proceedings. Now, going to Section 93A, when 93A is invoked, it is under the Supreme Court has held basically that it would not apply to a person who is an accused before that court. In the landmark judgment of Shamlal Mohanlal versus the state of Gujarat, the Supreme Court held that since Section 91, which is two sections preceding this, wherein a court or an officer may summon any person to produce any document before it, it would not apply to an accused person, as it would be contrary to his rights under Article 23 of self-incrimination. A general search warrant under 93B and 93C can be issued, but 93B specifically posits that such a search warrant cannot be given also as a matter of course. When anyone makes a petition to the court has to apply its mind, and there has to be specific averments to state that the articles or the documents or the things which are required to be searched for and seized are in the possession of somebody they are not aware of, or they do not know where those things are located. Only on such a condition could the court issue a search warrant under 93B, because it's such a wide and drastic power that it has to be exercised in a very circumspect manner, as it can have far-reaching consequences. Now, in certain cases, the High Court has set aside and quashed such a search warrant when it was found that on the basis of fraud, or when the person making the petition for a search under Section 93B was aware of who had possession of such a document, and in order to cover that up or to suppress it, had made misleading statements which had led to the court passing an order under Section 93B. Now, as far as possible, a court under Section 93 can even specify the place where this search is supposed to take place, or even only part of a place where it's supposed to take. You have to be again cognizant that this is impinging on the rights of many people. If this is a vastly public place, such as a hostel, and you give a general search warrant without any real good reason that the article could be located anywhere, that even people who are unconcerned with the proceedings in the court would be affected. Now, under Section 94, this is a remnants of the old CrPC as well, that such a search warrant, which is for either stolen property or forged documents or for certain goods which are objectionable or which fall under a list which is provided in the section itself, the court can issue a warrant under 94. But there are twin conditions. Again, this power which is to be exercised is not an unfettered right, and there is two restrictions, which are chiefly one, that the magistrate before making any warrant has to conduct an inquiry on the information that he has, and after conducting that inquiry, he has to come to a conclusion that any specific place is being used for either the deposit or sale of stolen articles, or B, for the deposit, sale, or production of any objectionable article. After that only, that is only after both these twin conditions are met, can the magistrate authorize officer above the rank of constable and above to enter any place, search any place, take possession of the stolen or objectionable article, and convey the article to the court or keep the article safe if it is not convenient to do so immediately. This section also empowers the person so authorized under 94 to take into custody any person who's found in or around the place and who appears to be suspect of commissioning the offense of either theft with regards to stolen properties or the deposit of the objectionable items. Again, if neither of these two twin conditions are not met, that is, there is no inquiry that is taken to show that there has been an application of mind and that the magistrate, on the basis of available material, has come to a conclusion that there has been that the place is being used for the deposit or sale of stolen articles, or B, for the deposit or sale or production of any objectionable article, then such an order would be subject and liable to be set aside. Section 94, the objectionable articles are basically what are laid out in the section where you can see there's counterfeit coins, pieces of metal in contravention of the Metal Tokens Act, counterfeit currency notes or stamps, forged documents, false seals, obscene objects which are referred to in section 292 of the IPC, and instruments or materials used for the production of the aforesaid objectionable articles. Now, section 95, even though it's there in chapter 7, is in essence actually a power which has been given to the state government with an enabling clause which allows the magistrate to give effect or enforce the compliance of the power exercised by the state. 95 basically postulates that in the event the state government forms an opinion that any publication or newspaper contains any matter which, when published, would be an offense as per the IPC sections so prescribed, it can by notification, and by notification it means a notification in the Gazette, state its grounds of opinion and declare that every copy of that publication to be forfeited to the government. It is a drastic and far-reaching power which is not often used, but once such a notification has been made, it would then justify not only a magistrate who could issue a warrant to the officer who's not less than the rank of a sub-inspector to search and seize the offending publications from any premises on the basis of some reasonable suspicion. It also grants a power to any police officer that in case he comes across any of these publications which are now to be forfeited to the government, he would be justified in seizing them. Now, section 95 is also one of the more. Section 97 is only when a person is said to be wrongfully confined and can be exercised for their release. Now, wrongful confinement would mean necessarily that it is a wrongful confinement or detention of the person that would amount to an offense under section 340 of the IPC. Before exercising his power under 97, again, the magistrate would have to come to a prima facie conclusion that the person has been wrongfully confined that he has conducted an inquiry to come to the conclusion that the person is wrongfully confined, and he has recorded his findings in order to issue the warrant. 97 is also an alternative remedy from approaching the High Court under Article 226 of the Constitution in a writ of habeas corpus. It can also be issued by a magistrate considering the far and wide scope of this and the urgency of when such a situation takes place. It provides for that even a person who is confined outside the local jurisdiction this warrant would be permissible to be executed, and it is not just restricted to the local jurisdiction of that magistrate. So Section 103 is one of the more direct powers which have been granted to a magistrate. It is self-explanatory that if a magistrate is competent enough to issue a search warrant for a particular place in the manner which is provided in the preceding sections, then he is also authorized to direct that search to be conducted in his presence. However, interestingly, the Supreme Court has said that even that in case there is a excess of authority or that search which is being conducted by a magistrate, even under 103, is in excess of his powers, then the person may resist that search. Now, in most of the judgments which we have come across, this sort of resistance has not really been successful because depending on the nature of the offense, it can also be construed as obstructing the lawful right of a public servant, which could generally attract another offense of Section 186 of the IPC. So, Section 100 of the CrPC provides for the general provisions that are applicable to searches which are not only searches under warrants issued by a magistrate, but also by the police. Today, these provisions are general and they mandate the manner in which the search is supposed to be conducted. Namely, now, if whoever who's residing in the premises that is being searched, whether if it is a residence or if it is a business, whoever is in charge of that place, he has to allow the concerned officer to freely access the premises and to give all sorts of cooperational and reasonable facilities to ensure that the search is taken. Now, the Act also provides that even in the case that someone is not willing to cooperate, then the concerned officer or the authorized officer is permitted that after he has announced his authority, that who he is, his identification, and on what basis he's conducting the search and why he's conducting the search, that officer is authorized to, in the manner which is provided under Section 47 of the CrPC, which basically permits the search and entry of any premises if you are going to arrest somebody, to break open any door, window, cupboard, etc., so that to effect and to ensure that the search and seizure as per the court order takes place. In the event, whilst conducting the search, it is observed that there is any person who is found either in the premises or around the premises, the language used is wide. That person also, even because the search warrants which are being given are for premises. It's given for looking for articles and objects in a particular place. But the Section 100C basically provides that even if you come to a place and you see that there is someone acting suspiciously or either inside or around it, you are entitled to even search that person. With also protection given that in case it is a woman who is found to be acting in that manner, then her search can only be conducted by another woman with a strict regard to decency. During a search which is conducted, now any search, the procedure also requires that you need two or more independent and respectable persons to attend. Now, these are called punches, where you require them to write a panchnama, that is a list of articles which have been seized or the procedure and the manner in which the search was conducted. And these two persons who are considered independent witnesses are supposed to also sign this panchnama to ensure the sanctity in the manner of the search which was conducted and the objects which had been retrieved. After the search is conducted, both any person who is there at the premises, whether it is somebody responsible for it from a standpoint of business or it's a resident, would be entitled to a list of all things that have been recovered from that place, or if he or she had been searched, then what has been recovered from him or her. Now, if you have noticed, 93, 94, 95, and 97, they all require that there has to be a reason to believe, a reason to suspect, that there has to be reasons under which an order under those sections has to be issued. Now, that order, when it has been issued, it must be in writing. Since it's a serious matter, it has to demonstrate that there's a clear application of mind, and that must be discerned only from looking at the order which is granting the search warrant. Now, when these reasons have been recorded, it should not disclose that it is to the subjective satisfaction by the magistrate. It should be something where any court which is exercising its supervision over the magistrate, whether either under revision or under writ jurisdiction, it should be able to examine whether the reasons for formation of the belief have any rational connection or a relevant bearing on the formation of that belief. And it should be based on the material which is on hand and not on any extraneous consideration or irrelevant consideration. Material should not be vague or indefinite or something far-fetched which would not justify the formation or a reasonable formation of that belief. Now, whilst in these exercise of these powers, considering the circumstances in which they are exercised, it is not expected that detailed or a minute inquiry is conducted. A prima facie satisfaction would suffice based on the actual material on hand. But in fact, they're even permitted to pass an ex parte order, but it has to be on the basis of material, and that material which has to be of that sort which justifies the grant of a search warrant. Now, if a magistrate mechanically records that he's simply of the opinion, or he believes that, that it's a simple order, that in the facts and circumstances in hand, I believe that the search was necessary, without assigning any cogent reasons, that would not suffice, because that would not indicate that what reasons have been actually adverted to, or how he has come to a conclusion, what is the material that he has considered before he has passed an order issuing a search warrant. Now, this is the first time that I have conducted a webinar for PLEA. So I thought I could maybe have some sort of interaction out here where, those watching could answer that what would an illegal search vitiate? A seizure conducted under that search. B, the subsequent investigation. C, the entire trial. D, all of the above. And E, none of the above. I'm not sure if they are permitted to type in out here. The popular answer appears to be D, which is all of the above. It's actually none of the above. Because what the Supreme Court has held in a plethora of decision, and specifically these are the case laws which, if you're curious to read about it and see then where it goes from here, that simply because a search was illegal, or that evidence had been obtained via an illegal search, it would not vitiate either the trial, the subsequent investigation, or the seizure which has been conducted under it. The Supreme Court has held that ultimately that exclusionary rule has been done away with even in the American courts, that every deviation from the prescribed procedure would not necessarily lead to the conclusion that search by the police would render the recovery of those articles which have been found in that illegal search irrelevant evidence, nor the discovery of those facts inadmissible at trial. What it basically means is that at the time of trial, this material can be brought, and under the Evidence Act, the only condition for material which is brought in trial is whether it is relevant or not. The only thing that can be granted is that once an illegal search has been conducted, that the material or the evidence which has been brought on record or the articles have been seized, it is incumbent on the trial court itself to examine that more carefully. Now, this as if you recall that under section 100, that even a punch witness, that if he does not, if in the absence of a punch witness, or in the case that in a trial the punch witnesses have turned hostile, that in itself would not affect the trial and would not take away from any independent evidence which could be led by the investigating agency to prove that the material had been gathered lawfully, or that there were certain extenuating circumstances which could not be overcome, and hence that certain prescribed procedures could not be followed. So basically, the Supreme Court says that the right at the threshold, we cannot come to a conclusion that this material is tainted, or that this evidence or this seizure can be disbelieved, and that the prosecution has to be given a chance to properly explain the circumstances which have made it impossible to comply with those provisions. Now, in Balbir Singh's case, the court also held that if any prejudice had been caused to the accused, and also look at the evidence in light of the perspective of any other corroboratory material, and not simply from a standpoint that any prescribed procedure could not be followed on basis of some extenuating circumstance. Each case, there's no hard and fast rule, and each case has to be independently examined to ensure that justice is done and that no prosecution is simply vitiated or negated on the basis of some irregularity which may not be glaring illegality.
Okay, so the first question is, can the police search a person's house without a warrant?
Yes, it can, but that is actually going to be part of the part 2 of this series. Now, under section 165 of the CrPC, the police are empowered to search a person depending on the circumstances.
So the second question is, can the police force a person to produce documents or things in his possession?
Under 91, a person who is not an accused can be summoned. But under if that person himself is an accused, it has been held that section under the judgment which I had cited earlier under Shamlal Mohanlal, that an accused is not considered or is not in the scope of section 91.
The third question is, can a police officer seize any property suspected to have been stolen or found under circumstances which create suspicion of the commission of an offense?
Yes, that would be under section 102 of the CrPC, where a power has been specifically given to a police to seize any such articles which have been suspected to have been involved in the commission of any. Of course, that itself also has its limitations, because the property which is considered is supposed to be movable property. So in that circumstance, immovable property would not fall under that bracket, but bank accounts would.
Can a search warrant be issued against an accused person in respect of documents or property which is known to be in his possession?
Yes, under section 93B, 93C, where a general power has been given, he would be entitled to be searched. 93A again would permits only the issuance of a search warrant for a person who could have been summoned under section 91 or section 92. Since an accused would not fall under those sections, 93A would not apply, but 93B or C would apply.
Can the police seize a person's property without a warrant?
Yes, that is again in under section 102.
Sir, with respect to the current amendment in the CrPC, would you like to throw some light regarding the present provision of search and seize in the new amendment of CrPC?
Actually, this is not an amendment of the CrPC. If you're talking about what has been introduced right now in the Parliament,
yes, sir.
we are far from that being enacted yet, because this still needs to be scrutinized by the parliamentary committee. By and large, the powers under the courts and police appear to be untouched. But until it has gone through the scrutiny committee and it's gone through debate, it is a little premature to start looking at its adoption, because it is not just a simple amendment. It basically repeals the entire CrPC along with the IPC and the Evidence Act. And there is significant changes in some provisions. But until final version has been shared, it might be a little premature to look at it.
Okay, sir.
Thank you so much, sir. Bye.
Great. Thank you so much.